What's going on, everyone? I've got absolutely explosive breaking news that just dropped, and it's about to send shockwaves through every anti-gun state in America. A federal appeals court has just issued a ruling so devastating to carry bans that anti-gun politicians are in full-blown panic mode right now. This isn't a minor setback for gun control. It does a ruling that completely obliterates the legal foundation that states have relied on for decades to justify carry restrictions. Buried inside this massive 87-page decision is a revelation so powerful that it fundamentally changes everything we thought we knew about Second Amendment law. And when you hear what these judges uncovered by tracing legal history all the way back to 1328, yes, 1328, medieval English common law, your jaw is going to hit the floor. Make sure you hit that subscribe button right now, because this is the kind of breaking Second Amendment news the mainstream media is desperately trying to bury, and you cannot afford to miss what's coming. This isn't your standard incremental court victory. What just happened represents the most comprehensive judicial destruction of carry permit schemes in modern American history. For the first time ever, a federal court has declared an entire state's residency-based carry permit system unconstitutional, using a legal framework so airtight that anti-gun states are left with no constitutional defense. The three-judge panel didn't just strike down one law. They established a legal standard that renders nearly every discretionary permit system in the country legally indefensible. And they did it by relying on historical evidence that gun control advocates have insisted for years simply didn't exist. Here's the part that's going to blow your mind. Judge Catherine Polk Fail didn't just cite recent Supreme Court cases like Bruen or Heller. She traced an unbroken chain of legal precedent protecting the right to carry arms for self-defense from 1328 through colonial America, the Founding Era, Reconstruction, and straight into the modern day. The court uncovered documented evidence showing that colonial America explicitly protected the right of travelers to carry arms across territorial boundaries. There are cases from Pennsylvania and Virginia demonstrating that denying carry rights based on residency was viewed as tyrannical even back then. For decades, more than 4.2 million Americans with valid carry permits have been criminalized simply for crossing into restrictive states. That ends now. The judges documented 23 separate historical examples from 1690 through 1868, showing that governments repeatedly rejected proposals to ban public carry, even during wartime, civil unrest, and major public safety crises. But here's the part that completely devastates the gun control establishment. In every historical instance where public carry was regulated, the government used objective shall-issue systems, never discretionary may-issue schemes that allow officials to deny permits based on subjective judgment. That finding alone destroys the core legal strategy anti-gun states have relied on for decades. What's even more shocking is how this judge connected historical dots that previous courts overlooked. She examined the original intent behind interstate travel and the right to bear arms as a universal American right, not a privilege tied to residency. When you hear what she found about how the Founding Fathers viewed strangers and travelers, you'll understand why this decision has sent gun control organizations into full panic. The judge made it crystal clear. So-called sensitive place designations and residency requirements are a legal fiction invented to sidestep the Constitution. She emphasized that if a right is fundamental, it doesn't disappear because you crossed a river. More than 8.7 million law-abiding Americans living in restrictive states just received the legal ammunition they need to challenge nearly every arbitrary carry restriction they've even forced to live under. Now, let me hit you with some statistics that will make your blood boil and show exactly why this ruling was inevitable. Right now, 8 states still operate may-issue or highly restrictive carry permit systems. Those laws affect roughly 87 million Americans, 87 million people whose constitutional rights are subject to the whims of government bureaucrats who can deny permits for virtually any reason they choose. Meanwhile, 27 states have constitutional carry, and another 15 states operate shall-issue systems with objective standards. That means over 245 million Americans can exercise their Second Amendment rights without begging permission from the government. Here's the statistic that absolutely demolishes the gun control narrative. New York recognizes carry permits from exactly 0 other states. 0. This is despite the fact that 27 states have constitutional carry and 42 states are shall issue. Meanwhile, states like Pennsylvania and Florida recognize permits from 35 or more states, proving beyond any doubt that reciprocity works, and does so without creating the bloodbaths anti-gun politicians constantly predict. According to FBI and CDC data spanning the last 15 years, states with constitutional carry have seen violent crime rates drop by an average of 8.2%, while may-issue states experienced average increases of 4.7% during the same period. That EES real-world evidence from millions of people over more than a decade, showing that more legal carry equals less crime. And it gets even better. The court cited studies showing that concealed carry permit holders are convicted of felonies at a rate of just 0.002%. Let that sink in. Here's the statistic that really shocks people. FBI crime data shows that out-of-state permit holders commit violent crimes at a rate of 0.003%. That makes them statistically safer than off-duty police officers, more law-abiding than elected officials, and infinitely more responsible than the criminals these restrictions were supposedly meant to stop. New York has effectively created a legal trap where someone with a spotless background check and a valid permit becomes a felon the moment they cross the Hudson River. The ruling exposed this system for exactly what it is. The court also revealed something gun control groups have hidden for years. In states that transitioned from may issue to shall issue systems, permit denial rates dropped from an average of 67% to less than 1%, and violent crime did not increase. It actually went down. In some New York jurisdictions, officials were denying up to 83% of permit applications, turning a constitutional right into a privilege reserved for the wealthy, politically connected, or famous. The judges called this exactly what it is: unconstitutional discrimination, creating a two-tier system of rights based on social status and political favoritism. But this case goes far beyond permits. This is where things get extremely dangerous for the anti-gun lobby. The ruling exposes what legal scholars are now calling constitutional dead zones, geographic areas where your fundamental rights vanish the moment you cross a state line. Think about how insane that is. You don't lose your First Amendment rights when you drive from New Jersey into New York. You don't lose your Fourth Amendment protections just because you're a non-resident. So why has the Second Amendment been treated like a second-class right for over a century? The judge found that these systems violate the Privileges and Immunities Clause of Article 4, Section 2, a part of the Constitution most people have never even heard of, but one specifically designed to prevent states from creating second-class citizenship for Americans who live elsewhere. And here's the part that has anti-gun politicians in total panic. This case isn't just a Second Amendment victory, it's a 14th Amendment revolution. The court ruled that residency requirements create an unconstitutional classification, triggering strict scrutiny. For those who don't know, strict scrutiny is the legal death penalty for government overreach. Under this standard, the government must prove a compelling interest and use the least restrictive means possible. Gun control laws almost never survive this test. By shifting the fight to equal protection, the court handed gun owners a second constitutional weapon. Even judges hostile to the Second Amendment struggle to dismiss equal protection claims. If a state provides a right to residence, it cannot deny that same right to law-abiding non-residents, period. This creates a constitutional framework that gun control advocates are almost powerless to defeat. And here's where the ruling becomes truly brilliant. The court didn't rely on just one doctrine. It combined three separate constitutional tests into a single legal gauntlet that almost no gun law can survive. First, the court applied the text, history, and tradition test from Bruen, requiring the government to prove that any gun restriction aligns with America and its historical tradition of firearms regulation. Second, the court applied strict scrutiny under the Equal Protection Clause because the right to bear arms is a fundamental constitutional right. And third, the court invoked the anti-commandeering doctrine, which prevents states from nullifying federal constitutional rights through local regulation. When you combine these three doctrines, you create a legal obstacle course that carry bans simply cannot survive. But here's the most lethal part of the strategy used in this ruling. The court relied on what's called negative historical evidence. In Bruen, the Supreme Court said modern gun laws must be consistent with historical tradition. Typically, the government tries to dig up some obscure 200-year-old statute to justify modern restrictions. Judge Fail flipped that strategy on its head. She examined periods of civil unrest, colonial warfare, frontier expansion, and public emergencies, and found that even in the most dangerous moments in American history, governments deliberately chose not to restrict the rights of travelers. This creates a devastating precedent. Since there is no historical record of residency-based carry bans in the 1700s, the government's legal argument collapses completely. Even more powerful is how the court handled analogical reasoning. The judges made it clear that you can simply point to the existence of some historical gun regulation and claim it justifies any modern law. Instead, courts must analyze how the regulation worked, why it existed, and whether it imposed a comparable burden. The court ruled that the government must show not only that a historical regulation existed, but that it was constitutional at the time, meaning it wasn't widely challenged or resisted. This level of scrutiny makes it nearly impossible for modern discretionary permit systems to survive, because they impose far greater burdens than anything found in history. And this is where the ruling absolutely destroys one of the gun control movement's favorite tactics, so-called sensitive places. After Bruen, anti-gun states believed they had found a loophole. They began declaring nearly every public space a sensitive place. airports, public transit, parks, restaurants, theaters, hospitals, and more. Some jurisdictions tried to label up to 95% of public areas as gun-free zones. The court obliterated this strategy with a single historical analysis. The judges found that throughout the founding era, in the 19th century, there were only 4 categories of places where carry could historically be restricted: legislative assemblies while in session, courthouses during proceedings, polling places on election day, and schools. That's it. 4. Everything else, including churches, markets, public gatherings, government buildings, and even powder magazines, was generally lawful for carry. The state argued that modern public spaces are more crowded and dangerous, requiring broader sensitive place bans. The judges didn't just reject that claim, they reversed it. They ruled that modern cities, filled with strangers and higher crime rates, actually increase the need for self-defense in public spaces. And here's the legal grenade hidden in that section. The court ruled that even in legitimate sensitive places, the government cannot impose blanket bans. Instead, it must use the least restrictive means possible, such as secure storage, temporary surrender procedures, or targeted exemptions. This requirement alone threatens to invalidate thousands of gun-free zone laws across the country, because almost none of them meet that standard. And this ruling doesn't stop with one state. It creates binding precedent across an entire federal circuit, impacting multiple states. The dominoes started falling almost immediately. Within 72 hours of this decision being published, Second Amendment advocacy groups filed 17 new federal lawsuits across 6 different states, all citing this ruling as direct precedent. This is a legal domino effect happening at lightning speed. Attorneys in California, Hawaii, New Jersey, Maryland, Connecticut, and Massachusetts are already copying Judge Fail's reasoning directly into their filings. California alone is now facing 5 new challenges to its concealed carry system, including one targeting the state's good moral character requirement, which the court described as an unconstitutionally vague standard that invites discrimination. Hawaii's entire may-issue framework is also under direct attack, and state officials are already signaling they may not even defend the law because this ruling makes their position legally untenable. What's especially devastating for anti-gun states is that this decision establishes powerful persuasive authority. Even courts, not technically bound by this ruling, are likely to follow it, because the historical analysis is so detailed and aligned with the Supreme Court's Bruen framework. We're already seeing federal judges in other circuits reference this case in early rulings, signaling they find the constitutional reasoning compelling. The constitutional roadmap is finally coming together. The wall around these restrictive states isn't just cracking, it's being demolished brick by brick. And if the legal implications weren't enough, there's a massive economic earthquake coming next. Tourism analysts estimate that carry-related travel restrictions cost restrictive states a combined $3.2 billion annually in lost tourism revenue. New York alone is estimated to lose $847 million per year, while California is losing over $1.2 billion annually as gun owners increasingly refuse to visit places where they can exercise their constitutional rights. But the real pain is just beginning. The insurance industry has started factoring Second Amendment litigation risk into government liability premiums. States with restrictive gun laws are seeing insurance costs jump 15 to 30% because insurers know these states are facing expensive and inevitable legal defeats. California alone is projected to spend over $47 million in legal defense costs and attorney fee awards over the next 3 years defending laws that this ruling suggests are constitutionally doomed. And it gets worse. Business relocation is being heavily influenced by gun laws. Recent Chamber of Commerce surveys show 23% of companies now list Second Amendment restrictions as a primary reason for avoiding certain states. Site selection experts report 31% of companies consider state gun laws when choosing where to expand. Restrictive gun policies are increasingly viewed as a competitive disadvantage. Texas and Florida are already capitalizing on this, openly promoting their strong Second Amendment protections as an economic advantage, and it's working. Federal contractors and companies with traveling employees are also pressuring restrictive states to change. When employees can legally carry in 42 states but become felons in 8, the compliance risk becomes unacceptable. This ruling has effectively transformed restrictive gun laws into financial liabilities. Now let's bring this home. This decision isn't about abstract legal theory. It directly affects your life. If you live in a restrictive state, this ruling provides the framework to challenge nearly every discriminatory carry law you face, from permit schemes to sensitive place bans. If you travel for work or family, this decision opens states that have been off limits for decades. For the first time in a generation, gun owners have real legal recourse. The days of becoming a felon simply for crossing a state line are numbered. We're already seeing a psychological shift among law enforcement and prosecutors. They know aggressive enforcement of carry laws now risks costly federal civil rights lawsuits. Prosecutors in some areas are already declining cases that would have been automatic charges just a year ago. Anti-gun politicians see it too. Their strategy of residency traps and gun-free zones is collapsing under constitutional scrutiny. They're running out of excuses and time. For those in constitutional or shall-issue states, this ruling strengthens your rights even further by creating historical guardrails that make future rollbacks extremely difficult. The court's analysis also reinforces that constitutional carry was the founding-era default, giving new momentum to permitless carry efforts nationwide. This decision confirms what gun owners have said for years. Most gun control laws are rooted in politics and fear, not history, evidence, or constitutional law. The court didn't just reject those arguments. It dismantled them using the government, us own data and sources. The question now isn't if the remaining states will fall, but when. This ruling provides the master key to unlocking the rest of the country. Whether you live in a free state or behind enemy lines, momentum is now fully on our side. I wanted to get this to you as fast as possible. This precedent is the hammer that's going to demolish unconstitutional gun laws from coast to coast. Drop a comment below. Which state do you think falls next? California, Hawaii, New Jersey? And if you want to stay ahead of every major Second Amendment victory, make sure you subscribe and turn on notifications. Thanks for watching. Stay vigilant, stay armed, and I'll see you in the next one.